Excerpt is entering a new level of development. How much money do you think this will bring to investors? Write answers in the comments. In the continuing legal struggle between Ripple and the U.S. Securities and Exchange Commission, John Deaton, a major XRP supporter, has shed light on possible conflicts of interest and regulatory capture that may have impacted the SEC's decision to launch legal action against Ripple. Ethereum is at the core of these claims. The elaborate tapestry known as ETH displays a complicated network of connections. The charges are complex and difficult to manage. Deaton summarized the most important elements in a recent tweet. Deaton draws attention to a series of incidents that link former SEC Chairman Jay Clayton and SEC staffer William Hinman. On March 26, 2018, Lowell Ness, a lawyer for a 16s, reportedly handed a message and a safe harbor agreement to Hyman. The paper particularly mentioned ETH. Soon after, Hyman proclaimed ETH to be a non-security, despite the fact that he was not formally retired and was still a profit-sharing partner with his law company, which was a member of the Enterprise Ethereum Alliance. According to Deaton, Hyman's law firm was a member of the EE, and Hyman was not retired, but rather a profit-sharing partner with his law firm when he declared ETH a non-security 10 weeks later. Furthermore, Deaton claims an obvious conflict of interest with Clayton's legal firm representing Joseph Lubin, ETH's co-founder, and ConsenSys, a significant ETH holder and booster. Deaton points out another possible conflict. Clayton's firm also brokered the merger between Quorum and ConsenSys, using the Jeepin coin, a direct competitor to Ripple and XRP. The participation of Joe Grunfest complicates things even further. According to Deaton, Grunfest was an essential element of the aforementioned working group, and he had communications with Ethereum founders as early as 2015. Deaton quotes Grunfest as saying, "He said XRP should not be treated any differently than ETH." Grunfest suspected the widespread evacuation of Clayton, Hyman, Berger, and others. He said there was no justification to file the complaint since XRP has traded openly for 7 years, and that innocent people with no connection to Ripple would suffer the most. Despite the appeals, Clayton decided to sue Ripple on his way out of the SEC. Clayton soon joined One River, which had already put a $1 billion wager on Bitcoin and Ethereum. Returning to Hyman, Deaton notes that Hyman returned to his law firm $15 million richer after less than 3 years at the SEC and then later became partners at A16s with the same people who helped put that list together, asking for the safe harbor for ETH. Furthermore, Deaton doubts Hyman's compliance with directions, alleging that his own SEC emails prove Hyman ignored that instruction and violated 18 U.C. 208(3) more times by meeting them. The allegations presented by Deaton are noteworthy, implying improper actions and relationships inside the SEC at the time of Ripple's lawsuit filing. As of the publication of this article, neither the SEC nor the parties implicated had issued any formal remarks in response to Deaton's charges. With the second deadline for the U.S. SEC's spot Bitcoin ETH set for the third week of October 2023, the focus is now on other important events affecting the crypto market. On September 27, 2023, at 10 a.m. Eastern Time, U.S. Securities and Exchange Commission Chair Gary Gensler is expected to testify before the House Financial Services Committee on the agency's supervision. Members of the committee have a history of vehemently opposing Gensler's ideas, particularly on the crypto regulatory framework. In an April 2023 hearing, Committee Chairman Patrick McKentry questioned the Commission Chair if Ethereum, ETH, was a security or a commodity. This might be a topic of discussion again at the forthcoming hearing in the context of the XRP lawsuit judgment, which classified token sales to regular customers as not securities. The Bureau of Economic Analysis is scheduled to issue the Personal Consumption Expenditures (PESI) price index data for August on September 29, 2023. Ripple will hold the proper party in New York City on September 29, 2023. It will be a communal celebration of liberation from legal difficulties as a result of the recent partial success in the SEC litigation. While the event has no direct influence on XRP demand and supply, it may have an effect on market mood. Furthermore, it is likely that the corporation would make no major announcements during the event. Ripple's chief legal officer, CLO, Stuart Alderoty, has joined the chorus of those expressing dissatisfaction with SEC Chair Gary Gensler's appearance before Congress. As Ripple continues its legal struggle with the Securities and Exchange Commission, SEC, over the categorization of XRP, Alderoty examines Gensler's statements during the hearing, notably his evasive replies on the subject of securities under use of Rust law. According to Alderoty, Gensler seemed to smugly evade question after question, which irritated numerous members of Congress. The Ripple CLO, on the other hand, emphasizes a specific moment when Rep. Richie Torres of New York's 15th Congressional District tried to put Gensler on the spot. Rep. Torres highlighted concerns throughout the hearing about the SEC's wide understanding of a investment contract, which seems to include whatever the agency sees proper. Torres especially questioned the SEC chair on its use of the concept to classify practically all cryptocurrencies as securities, a move that Ripple and Coinbase have strongly opposed. Rep. Torres cited a recent study by 6 prominent legal experts, including a Yale University professor, that found no Supreme Court judgment has ever treated a scheme without a real contract as an investment contract. When he questioned Gensler whether there had been any earlier Supreme Court instances in which an investment relationship was held to be such in the absence of an express contract, the SEC chair's answer was evasive. Gensler elected not to respond directly, instead referring to the SEC's lawyers, who are now engaged in pending legal proceedings. Rep. Torres called Gensler's dodge baffling, given that the investment contract concept is the foundation of the SEC's legal proceedings against cryptocurrency. Related firms. It remains to be seen if other cryptocurrency firms engaging in legal battles with the SEC would follow the congressman's logic in future court trials. As the Ripple SEC fight continues, the SEC chair's testimony emphasizes the need for clarity and uniformity in the categorization of digital assets in the U.S. legal framework. The unique viewpoint created here provides light on the criticism made at SEC Chair Gary Gensler by exposing his evasive comments and challenges to support the SEC's broader definition of an investment contract. The SEC filed an interlocutory appeal with the court after Judge Analisa Torres ruled that programmatic XRP sales did not constitute as securities. This meant that the U.S. Securities and Exchange Commission, SEC, did not agree with the verdict, and although the court accepted the interlocutory appeal, pro-XRP lawyer John Deaton termed the action ludicrous as he dismantled the SEC's case. Deaton discussed the SEC's interlocutory appeal in a piece titled The Irony of Interlocutory Appeal. The essay, which was published on the Crypto Law website on Thursday, September 28, outlines how the appeal filing might wind up favoring Ripple. The pro-XRP lawyer notes that Judge Torres' decision to approve the request for appeal was anticipated, and the argument was that such an appeal would allow the judge to clarify her reasons for deciding in favor of Ripple. Empower Oversight Whistleblowers as Research, a rigorous watchdog organization, has spearheaded another incisive Freedom of Information Act (FOIA) endeavor. This strategy is geared on clarifying Jay Clayton's interactions with a pantheon of parties considered crucial to the SEC's often controversial Bitcoin enforcement approaches. Clayton's tenure as the SEC's most powerful chair, which lasted from May 4, 2017 to December 23, 2020, included a number of landmark occurrences. At the forefront was Clayton's declaration of Bitcoin's non-security status, which was echoed by other top figures about Ether. Bill Hyman delivered his notorious lecture in which he claimed that ETH is decentralized and so does not qualify as a security. Hyman's speech disregarded the advice of other authorities, as revealed in the legal dispute between Ripple and the SEC. These statements have a significant amplifying impact on the value dynamics of these digital assets. This rising trend, however, was disrupted by the SEC's unexpected legal onslaught against Ripple, which questioned the XRP token status as a security. This dispute, when paired with Clayton's later affiliation with One River Asset Management, a hedge fund with a sole portfolio emphasis on Bitcoin and Ether, fueled speculation. Among these swings, Empower Oversight's press release stated unequivocally, Empower Oversight has submitted a new Freedom of Information Act, AIA, request seeking communications between Jay Clayton regarding the agency's ostensible misalignment in cryptocurrency enforcement stratagems. Empower Oversight tries to dramatically widen the nexus of persons possibly enmeshed inside Clayton's contact environment in the convoluted build of this newly minted FOIA petition, aimed at Raymond Mcinerney, the SEC's main FOIA custodian. The list, whose names range from Jasmine Burgess to John D'Agostino et al., attempts to crystallize any underlying conflicts of interest entwined within Mr. Clayton's SEC stewardship. The whole issue has not gone ignored by cryptocurrency stakeholders. When I first raised the huge conflicts of interest, I was called a conspiracy theorist by many in the industry, said renowned ProXRP attorney Johnny Deaton via XAU, previously Twitter. Empower Oversight found emails demonstrating Hyman violated 18 UC 208 on many occasions with Clayton's full knowledge and implicit permission. Is Empower Oversight a conspiracy theorist as well? Let's not forget, Clayton was the only commissioner who saw and read the draft speech before it was delivered, Deaton said. Hinman did not send a copy to Hester Pierce. That's correct. Crypto. Mom was not informed about the most important speech in crypto history. Ripple is determined to win the legal fight with the U.S. Securities and Exchange Commission, SEC. As a result, the corporation just engaged a well-known lawyer to assist in that aim. James K. Filan, a defense lawyer and former federal prosecutor, revealed on X Twitter that Rahul Mukhi would defend Ripple and its CEO Brad Garlinghouse in their current dispute with America's securities regulators. Mukhi has extensive expertise in the area, having worked as an assistant United States attorney from 2010 until 2016. He eventually became a lawyer and partner at the multinational legal firm Cleary Gottlieb Steen Hamilton & legal firm Cleary Gottlieb Steen Hamilton LP. Mukhi has overseen major cases including financial and tax fraud, public corruption, cybercrime, money laundering, and organized crime during the last decade. The legal conflict began in December 2020 when the SEC filed a complaint alleging Ripple of trading billions of dollars in XRP as a securities without registering with the commission. In the years that followed, the intense struggle progressed through many phases as both entities launched bullets at one another. However, Ripple seems to have a significant edge since, in July, a U.S. court found that most of its XR sales did not represent an offer of investment contract.